My name is Levine, and I am one of the co-chairs of the First Amendment Salon on behalf of Ron Collins and David Scover. I'd like to welcome all of you to these.
You're getting lots of respect.
They're not well behaved.
Can you hear us? No. Oh, all right. Can you see me now?
Duh.
Do you want to sit
That's all right, George. All right. Anyway, we will proceed. I'd like to welcome you all in New York and New Haven and DC. The DC people apparently can't hear us now, but hopefully they will soon, to the 17th First Amendment Salon. We produce these salons in cooperation with the Floyd Abrams Institute for Freedom of Expression here at Yale Law School. I'd like to particularly thank Heather Branch and Sandy Barron for all of their hard work in helping us put these on. For those of you who have not been to one of these before, the purpose of the salons is to bring together practitioners who practice in the First Amendment area, academics who study and write in the First Amendment area, First Amendment advocates and journalists to talk about issues contemporary and more timeless in areas relating to freedom of expression. We thought that it made a lot of sense this year to do a salon in conjunction with the Free Expression Scholars Conference here at the law school to give practitioners and advocates and journalists a sense of what the Academy is thinking about these days in the area of freedom of expression and to give the scholars a chance to get some feedback from the folks who are in the trenches litigating the cases and advocating the issues. Our topic today is Rethinking Reno and Section 230, How Should We Regulate Social Media? We came up with this topic because when the papers all came in for the conference, for the Scholars Conference, we took a look at them, and one thing that jumped out to us was how many of them sought to grapple with issues that are raised by the internet, by social media, and tried to come to grips with the notion of how can we, consistent with our commitment to freedom of expression, regulate that medium of expression. I have to say that once the invitations went out, we got feedback from more than a couple of our regulars who attend these salons asking about the question that we posed in the title of the program, how should we regulate social media? A lot of folks on the practicing side said, shouldn't the question be, should we regulate social media, not how can we regulate social media? So when we get to the discussion portion of this, be prepared to get some questions in that vein. Session today is going to be moderated by Jack Balkin. Jack is the Knight Professor of Constitutional Law and the First Amendment here at the law school. He is the founder and director of the Information Society Project and the director of the Abrams Institute. Jack will introduce our principal discussants, and then we'll lead the discussion first with them and then with all of you. Thanks, Jack.
Thank you. Oh, and Lee, when we open it up for questions, I want to get some questions from New York and hopefully DC. So if we have a procedure by which we take questions, can you let me know when we get to that part? I just say, can we get a question from New York?
You do it as you see fit.
All right, very good. Hey, everyone, how are you? It is so nice to see you all here. You know, this is the opening act of the Free Expression Scholars Conference. And so we have here a bunch of free expression scholars. We have, in no particular order, Genevieve Lakier from the University of Chicago, Enrique Armijo from Weiland University, right, in North Carolina, and Morgan Weiland, who is getting her PhD in communications at Stanford, right?
That is correct.
That is correct. We have a great bunch of questions to ask them, which I will proceed to ask. They will answer them. At that point, hilarity will ensue. That's how it goes. So here's the first question. The first question is tied to what Lee was just talking about. When we think about the issue of online free expression, free speech, how important is the First Amendment anyway these days? Is the First Amendment the key issue, or is it going to be things like the telecom system, congressional legislation, business models, technological design, media concentration, which would be an issue of antitrust? So that's really the first question I want to start with. Is the First Amendment the key player these days in these issues, or is it something else? You want to start, Morgan?
Sure, yeah. I mean, I think the answer to the question, given the way that First Amendment is currently interpreted, the current status of the doctrine, the answer to that question is no, because First Amendment doctrine at this point doesn't really provide tools to create spaces and structures for the affirmative protection of free expression. That sort of tradition in First Amendment doctrine is marginalized as compared to what many describe as a negative liberty tradition. And in my view, protecting, and the phrase you use in the question is protecting the digital public sphere. If we're going to protect the digital public sphere, then it's essential that we would have to have a First Amendment that paid a lot of attention not only to speakers, but also to listeners, that took into account the whole scope of what Habermas would think of as communicative action, which is necessary to even constitute a public sphere. So because of the state of First Amendment doctrine, I don't think it's particularly important in terms of protecting the digital public sphere. But I would quickly add that even though it's not affirmatively important to protect it, it does present a type of threat. Because of the way the speech doctrine, the First Amendment does present a sort of threat to the types of regulations that you might think of, telecommunications, other types of regulations, and I'll tell you why. Because, as many scholars have pointed out, people on this panel included, there is major First Amendment expansionism now, especially to types of speakers and actors who I think are peripheral to the core purposes of the First Amendment. And those types of actors will advance First Amendment claims that will undermine our ability to move forward with the types of regulations that we might be thinking of under, for example, telecommunications. Quick example. In the recent net neutrality litigation before this most recent overturning of it, the ISPs, the internet service providers, argued that net neutrality was unconstitutional because it violated their speech rights and that they saw themselves as speech actors when they were transmitting data around the internet. That is a novel First Amendment argument. It's clever lawyering, but I think that is the kind of argument that is very much at the periphery of the point of why we have First Amendment protections, and it's precisely those types of arguments that are in line with the current state of First Amendment doctrine that could actually undermine the project of protecting the digital public sphere using statutory common law-based tools.
That's assuming the First Amendment is and has to be a particular way.
Oh yes, but let's talk about how it could change. Like, absolutely.
I mean,
I'm going to assume I asked Genevieve the question.
Yes, please.
Because if we think about what the First Amendment, the question was a little ambiguous about what exactly you meant by the First Amendment. I mean, we could say right now, how important a role does the First Amendment play in the regulation of the social media? Not a very important role at all. It doesn't. For one thing, it gets invoked in these kinds of claims, although they haven't been successfully resolved. It also doesn't prevent the tremendous amount of speech regulation that already occurs on the internet. So this question, should there be regulation? There already is regulation. We're not in a regulation-free zone. I mean, if we think about a tremendous amount of speech that gets taken down on copyright grounds, the enforcement of the child porn laws, and of course all of the private governance that the internet companies are constantly doing. It's a very heavily regulated space. It's just a space that's regulated in part by public authorities, acting hand in glove with the private companies, and in part by the private companies acting in the shadow of the law or just in shadow. We don't really know what they're doing. So that's what's happening now. But if we think about what role the First Amendment could play or should play, I mean, it seems hard for me to understand why it should play any different a role on the internet than it plays in ordinary life. I teach the First Amendment. I teach my students that constitutional law plays an important but a limited role in the organization, the regulation of everyday life. The property laws, contract law, economic regulation plays a tremendously important role, but that doesn't mean that the Constitution is not important. It sets the baseline, it sets the framework, and it helps establish norms. So one would think that the First Amendment should be playing that role, and the fact that it may not be seems like a tremendous problem to me. Doesn't mean that then the First Amendment should play a role. It means that we need to rethink our First Amendment doctrine if it's preventing courts from interpreting the First Amendment to do that.
Very good. Enrique, do you have a view on this?
I do. I still think that the First Amendment is the biggest dog in the pound, or the meanest chicken in the coop, or whatever you want. But even if you're kind of in favor of a very aggressive First Amendment, which I am, I think you do have to concede that sometimes the influence of the First Amendment in this space is negative. And I think what illustrates that the best is the issue of anonymity. I mean, you have throughout the Supreme Court opinions, most strikingly in McIntyre versus Ohio Elections Commission, you have this. You just have these beautifully written opinions about how important anonymity is in the First Amendment context. And then you have a networked public sphere where I think most of us would agree that the effects of anonymity are on net harmful. And not completely negative. I mean, there are a lot of Miss McIntyres on Twitter, but there are a lot more trolls on Twitter than there are Miss McIntyres. And the trolls are the ones who attack the people like Miss McIntyre. So you have some of the same power dynamics with respect to the effects of anonymous speech, and really the weaponization of anonymity that has taken place in the online context. And it's a lot of the social science on this is in a way common sense. There's this paper by Ian Rowe, Civility 2.0, where he just took a story of Washington Post that on its website that did not allow anonymity and compared those comments to the same the same comments to the same story where anonymity was permitted, and it was striking the degree to which which conversation was healthier, however you want to define it. So the cost of anonymity, which is a First Amendment value that's almost universally protected, results, I think, in the online context in a degraded forum. And then when you have the First Amendment value kind of internalized in the design of the platform, then it becomes a norm where you see people basically asserting First Amendment defenses to being outed. Even though the First Amendment doesn't apply, that value of anonymity is so ingrained in the design of the platform that it tends to bollocks things up.
It turns out, as I teach my students, that the most effective guarantor of free speech online is Section 230 of the 1996 Telecom Act. So I'll stick with you, Enrique, and just ask. Congress modified Section 230 recently in FOSTA SESTA. And so the question is first of all, what do you think of that? Do you think that was a good idea? And would you change Section 230 in any way?
Well, I want to say, who cares what I think? Because
I care what you think.
Well, let me do an impression. Senator, I agree, we are responsible for the content. That's Mark Zuckerberg. He said that last week. So, and then it was interesting, the discussion was a lot about artificial intelligence and the degree to which artificial intelligence is going to completely solve the problem of illegal or excessively harmful content online. And then if you see the community standards that Facebook put out just a week later, really pulled back on the idea that artificial intelligence is going to solve all these problems. And that has to be the case. I mean, I'm not a scientist, not even a Scientologist, but I know he's not talking about word searches, but these issues are so context dependent, particularly with respect to defamation. There's no word search that is going to help you spot, flag, and take down defamation online. But I think, despite all that, I think Mr. Zuckerberg, maybe to the regret of his attorneys, said that it might be time to consider whether or not there should be a reasonableness standard, a knowing standard with respect to third-party content on Section 230. Now, the question is how that should be. You should
explain to the audience, you mean the idea of notice and takedown. All right, so explain how it would work.
Well, that's a good question. I mean,
I only ask good questions.
Yes, I know. The challenge here is that you don't want Facebook, which is spending millions of dollars in research on artificial intelligence and can hire maybe not enough people to moderate content, but it's hiring hundreds of people to moderate content every day, to set the standard for what no reasonable takedown is after you get the notice. So if we agree that some modification is necessary, and as I said, I think even Mark Zuckerberg agrees about that, we have to really think hard about where we're going to set the standard such that we can preserve what Section 230 was really about, which is protecting the startup company. There's no entrant into this new space. And we'll probably talk about whether or not there should be an interest in this new space. It's going to be able to set a standard that Facebook sets with respect to what it does with respect to notice and takedown. So maybe we could think about this in the way that we used to think about medical malpractice standards of care, where you have one standard of care of reasonableness for the Facebooks of the world, and then you have one standard of care that's much lower for the newer Facebooks of the world, or the Facebook 2.0.
So, or you could just say if you have less than 100,000 customers
Right.
and users, you're grandfathered
Right.
until such time.
Right.
Did you want
Which
to
is what Jonathan Zittrain proposed, something very similar to this a couple of years ago, sort of a two-tiered approach where you would have some line and like put an asterisk next to what that line is, some line above which, and it might be about number of users or it might be market cap or something, above which a different sort of standard is required for immunity to attach, some sort of responsibility, and below which you have fewer than X number of users or whatever. Those companies would have CDA 230 protection as it is now, and it's precisely designed with the idea of preserving the benefits of CDA 230, innovation, new entrants to the market, and ensuring robust speech. And so, that's one proposal on offer, but the asterisk, what's the line? How do you determine what that line is, and how administrable could that be? I think that would be very important to sort out if we were to pursue that.
It wasn't entirely clear to me.
Yeah.
Forget about, for putting the line aside, the question is, what's the standard? Is the standard that if you are Facebook and you receive a notice from anyone in the world saying, I regard the last post by robot number 33 to be in violation of, you name it, it's defamatory, it is abusive, it is false, then you have X number of hours to remove it? Is that the proposal? In other words, we have to talk about, first of all, who would be able to give notice, right? The question is, notice about what? What kind of speech would you give notice on? And then what would be the response of the social media company? Would they have 48 hours to remove it? Would they have 72 hours to remove it?
And who would be reviewing it?
And who would review it, right? And then the idea is, if you're not satisfied, would they have counter notice? If they're not satisfied, would you then have a right to appeal to a court? This is, you see, now this is looking more and more like right to be forgotten in Europe.
Well, and also, I mean, so my understanding is the whole point of Section 230 is to get the courts out of it so that the social media companies, the internet companies can make their own judgments about what speech to allow and what speech to get rid of without the intrusive role of the state. And this is where the First Amendment doesn't apply. But if we start to have this much more nuanced or reasonable standard that presumably judges are going to be reviewing, all of a sudden we have the government intervening, but intervening, note, in only one direction. Intervening only when the social media is asked to take down something that it's already accepted, but there's no regulation of what it accepts, of what it chooses, its own censorship decisions not to allow speech in the first place. So we have a non-parallel regulation where we're giving people the right to say, you have to take this down, but we're not giving people the right to say, I want access, affirmative access. Why not then just get rid of the whole Section 230 model altogether if we think that just leaving the government out is not going to work, and start to think about social media companies as something like public utilities or common carriers. I would not be entirely averse to going further and thinking of them as state actors where there are affirmative rights of access that are subject to judicial regulation. And we're moving away from the Section 230 model altogether, which is all about getting the government out.
Well,
why do this kind of halfway in?
Before we get to that, I want to point out that, so there are a lot of different models on the table. Section 230 has two halves. Section 230 subsection 1 is what most people talk about. Section 230 subsection 2, which basically holds you harmless if you remove content, is what you're really saying is the problem. Yeah. It's not touched by this change.
That's right.
And many people have argued that...
And nor is anyone suggesting it should be, right? That's just not on the table.
No, I'm not. That's not true at all. I mean, for example, I have argued that that you might want to create some kind of curatorial due process right. That is, if they take you off, then you need to get an explanation for why. That would be a modification of 232, not 231. And another issue is you model on the DMCA. DMCA is notice counter notice. That's a completely different model too. The other suggestion you made, though, is completely scrap the whole model, which treats the social media company as a private company. That is a purely private company, and move to a different model of public utility or as a state actor. I just want to point out, though, that any change in Section 230, raises the possibility that the reform will be unconstitutional, because we assume that Section 230 itself is consistent with the First Amendment as a structural regulation of telecommunications facilities. But if you vary from the baseline, which we assume is constitutional, you have state action on the part of Congress. And then we have to know whether or not the change from the baseline would be constitutional. And so it turns out you will have to go to some set of questions similar to Genevieve's in order to answer that question. That is, Genevieve says if they're already common carriers, if they're already public utilities, well then, in fact, moving away from that baseline won't present any constitutional problem. But if they are purely private companies, like General Mills, for example, if they sell toothpaste, if that's what they are, then in fact moving away from Section 230 as the baseline will potentially create a First Amendment problem. And your First Amendment opportunism will immediately arise.
But only potentially, right? I mean, if the speech at issue here is unlawful speech, defamatory speech, or threats.
So other countries in Latin America, constitutional courts have held that their equivalent of Section 230 is required by the free speech principle. Mm-hmm. That is to say, under that set of reasoning, if Congress did not pass something like Section 230, there would be a First Amendment problem. And certainly, we know at a baseline that if Congress imposed strict liability on social media companies for content that was found on their sites, without any notice, without any, that would probably violate Smith versus California. So some part of Section 230 is probably required by the First Amendment. The question is how much? Unless, of course, you say we separate out the delivery mechanisms from the rest of a social media company.
Well, you could just treat them as publishers,
yeah.
Right? I mean, you could just say New York Times and Sullivan applies, the whole sort of...
But I think that would also violate the First Amendment.
Section 230 is just an affirmative defense to the republication rule.
Right.
I mean, I don't think you have to go all the way to the state action doctrine necessarily to get the same result. I mean, I think you could just say Section 230 was to develop a public sphere. These companies were developing. They didn't have the capacity to review third-party content, so we're going to give them immunization from a republication rule, which applies to every other person who deals with third-party content. Newspapers, individuals. I mean, we're all subject to the republication rule. So I think there's a middle ground here that is deserving of exploration. And I just want to take a quick step back and think and say that 2 years ago, Jack's question would have been, is Facebook a tech company or a media company? I mean, just think of how far we've come when we're actually talking about some of these issues, which actually probably frightens some people.
Which brings me to question number 3.
Can I have a quick question before we move on.
Right.
I'm curious, and to take over your role and ask questions to other people. What's the problem that we're trying to solve? I mean, I think there is a legitimate problem that we may be solving if we change CDA 230, but from a policy point of view, are we worried about access? Which, if that's the concern, then maybe we could get at the issue of access by breaking up these companies and ensuring that there are more Facebook, so there's not just Facebook, Twitter, and Google. Or are we concerned about the fact that there is so much abuse that happens on these platforms that we see rampant misinformation, cyberbullying, harassment, trolling, and all sorts of things? What are we most concerned about? Because if we're concerned about the latter, if we're concerned about the quality of the community, then I worry about the sort of the most extreme hypo that you teased out, thinking of platforms like under Marsh, because then they can't really regulate at all. And so anything
regulates all the time.
It seems like it would be more anything goes, and I would worry about it being harder for the platforms to make decisions that go above the minimum of the First Amendment.
So if we think that what these companies, not technology companies, whatever these companies are doing, are in fact governing a whole array of speech, if we recognize that Facebook and these other social media companies are places which are important sites in our public sphere, places where important debates are happening, people's conception of the world is being influenced in important ways, and the agents who are making all these decisions are doing it in private. We have no idea how they're doing it, and they're not subject to any kind of judicial review or reasoned elaboration. That's what we're worried about. And I don't see, why do I have to choose? I was actually talking to a friend about this earlier today, and she wanted to know, are you worried more about access? Are you worried about people getting abusive? Right. I'm worried about both. I'm worried about the fact that my guess is what companies like Facebook are doing is that they're denying access to speech I like, on reasons I don't understand, and it's also a space in which there's a lot of abuse. So I don't know why I have to choose. The problem for any speech governor is both. We worry about the government both when it censors, and we worry about the government when it allows abuse to occur.
But your proposed solutions would have different effects in those directions. Some of your proposals would be more directed toward one problem, and some would be more directed toward the other.
But there is also a dimension of it in that I think we've reached a funny impasse in First Amendment law if the fact that our doctrine has become so restrictive in its ability to allow the government to regulate leads us to say, okay, well, let's just cut off a really important part of our contemporary public sphere, and let's pretend that it's not really part of the rest of the public sphere for First Amendment purposes, because we don't like what that's going to do. I think that distorts the doctrine as a whole, because it takes the pressure off the courts to really think about the harms of the doctrine that they're creating, and divides the constituency that might be pushing for doctrinal change as well as sort of regulatory change. And it's also just bizarre that we're going to say this really important space of speech, somehow the First Amendment doesn't apply in any real way.
It's crazy.
It's crazy, and so therefore we have a doctrinal problem.
Let me take a particular. Let me take a particular.
Okay.
In which the question of the First Amendment's protection matters. Many people, this sounds like Donald Trump, many people think.
Beautiful people.
Right.
The best
people are concerned that foreign online propaganda may have swayed the American election, but there was no collusion. In 2016, there's also evidence of foreign online propaganda in the Brexit vote and in other elections around Western Europe as well. So my question to you is, this is going to implicate all the points you just raised, what is the best way, if at all, maybe you should say nope, what problem? What is the best way at all to deal with the problem of foreign online propaganda consistent with the First Amendment? Would you like to begin?
So how many people have heard of the Countering Foreign Propaganda and Disinformation Act? So this was a law that passed in May 2016 in the House by conference vote and passed in the Senate by a vote of 92-7. Now you might think that any law that passes the Senate by a vote of 92-7 by definition does nothing. And it's pretty close to what this law does, right? So it tells various actors in the federal government, state, defense, Director of National Intelligence, Board of Broadcasting Governors to establish a response center to develop and disseminate fact-based narratives to counter propaganda and disinformation directed at U.S. allies and partners. So that sounds like...
Allies and partners about the U.S. itself?
Yes.
Okay, I love that.
So this sounds like small beer, right? But don't get mad at the Obama administration. Don't get mad at Congress. Get mad at Justice Brandeis. Because this is exactly what he was talking about in the Whitney concurrence, right? This is the remedy to propaganda. Counter speech is the remedy to propaganda. And the fact that we have foreign actors involved in this space, I think it's an open question as to whether or not that changes anything. And I think any action that the government might take with respect to limiting access to foreign propaganda would run into the Lamont versus Postmaster General problem. I mean, I think it's very easy to conceive of a case where the government takes some action in this space and somebody comes along and says, oh, you've interfered with my First Amendment right to receive foreign propaganda. Lamont versus Postmaster General, he gets his Peking Daily, I get my Russian bot chat.
I really want to hear what Vladimir has to say.
Yes, you can't take Vladimir away from me. So there are First Amendment problems in all directions, which is why I think on this issue, I think I stand with Brandeis.
So your view is that what problem? Or if you think there's a problem, it's not something that we can do very much about. Genevieve, what do you think?
I'm not sure. I kind of agree on I'm not sure whether it matters that it's foreign propaganda. I mean, I think falsity is a problem right now conceptually for what we do, how we regulate, because false speech is generally protected and seems to be more protected under Alvarez, and yet it also seems like a problem. But isn't this what fact checkers are here for? I don't really understand why. I mean, this doesn't seem like a problem that needs to be about prohibiting speech. This is a problem about consumers.
Does it matter at all if Vladimir actually is presenting himself as a fellow Texan?
Well, so this is about consumers not understanding the nature of the thing that they're consuming. Right. It's like drug labeling. You want to buy the drug, you want to know that you're getting the thing that it says it is.
Right.
that seems like a different kind of problem than that we need to get rid of the speech. Now, the problem is, could we mandate fact-checking? Who would be determining what the fact-checking is? This seems like clearly a problem, but I imagine that the media companies are going to develop their own forms of fact-checking as a means of, because consumers are now worried about the problem of fake news.
But this sounds very much like your belief that we really should rely on Facebook and Twitter to take down content that they don't like, when it's content you don't like.
Oh, I don't want them to take it down.
You just want them to mark it as this is Russian propaganda.
You could have a regime in which any speech that is about political candidates, say, has, and this could be voluntary on part of the media companies, it gets run through a fact check and it gets stars, like this is 3 Pinocchios, 2 Pinocchios, or 1 Pinocchios.
And it doesn't matter whether it comes from Russia or anyone. But
yeah, I don't see why it should matter.
In 2016 was that it wasn't a speech that was advising you to vote for a candidate. It was things like Texas should secede from the Union, or Black Lives Matter is having a rally and we think it's time to kill white people. Or conversely, same outfit, Black Lives Matter is a terrorist organization and they're all secretly Muslims.
Well, some of it was like the pizza ring in the basement.
Yeah.
So could you devise it more broadly? Sure, a public figure, a pressing public issue. Now, I don't know whether the government can regulate this under the First Amendment.
You're starting to sound quite libertarian. I'm surprised at the about face that you've suddenly...
I'm surprised as well, but this, yeah. I'm surprised.
No big deal unless it's your pizzeria.
Why can't we think about it as a form of like outside spending on campaigns that could be regulated under the Federal Election Campaign Act? It seems that possibly this sort of speech, if it's foreigners spending money in a way that is targeted to affect our election, even if it's not clearly a campaign ad, maybe we could have a broader interpretation of that in a way that would allow us to go after that sort of content.
So which
would be consistent with the First Amendment.
So your view is that we do have a problem in doctrine, that is, there are electioneering communications clearly by foreign agents can be regulated, both expenditures and contributions. The question is, what if it's a non-electioneering?
Yes, we'd have to broaden the definition of electioneering in order to sort of bring in all of the sorts of problematic content that we were talking about.
And that's going to be your problem under Lamont, I take it, yes?
Well, yes. I mean, the drug label analogy is terrific, but if the drug company had its druthers, unless to avoid tort liability, the label would be very different than if the government tells the drug company that the label has to be on the drug.
Well, it tells it has to be accurate, not misleading. It doesn't exactly say what the label has to say. It has specifications.
Right.
It does seem like that's the right kind of, that's what we want. I don't know why.
In other words, I can't pose as a Macedonian. If I pose as a Macedonian, the government can punish me. And if a Macedonian poses as a person from Connecticut, the government can punish that too. Is that the idea? That impersonating, pretending to be something that you're not, that is from a country that you're not from, can be punished by the government if you speak? Is that the idea?
Pretending to be a person if you're a bot, right? If it's a bot generated.
Well, bots don't have any money. But my point is, I'm talking about the idea that you're from Macedonia and you tell everyone that you're from Amarillo. I take it that you were talking about anonymity and pseudonymity are linked, aren't they, in First Amendment doctrine?
I mean, I was the counter-speech guy. I mean, I think that if somebody says, hey, I'm from Texas, and then the other people come in and say, no, you're from Macedonia.
You're from Macedonia. That's part of Texas.
I think that's
it's right near San Antonio. Didn't you know that?
Exactly.
Can I ask Morgan, why does it matter if it's foreign? Because you think this should only apply to foreign money or whatever, foreign speech. And to me, it's not obvious why that should matter. I mean, if we have a very bounded notion of our speech community, maybe. But do we really want to say, I mean, if Le Monde wants to, have an article, we can prohibit Facebook from sharing that, whatever.
I do worry about foreign influence on elections, and I think we can draw a line where we say we shouldn't allow, maybe there's a X number of months before the election or some sort of rule where we don't allow foreign actors to influence the nature of our elections because of the risk. The risk is so high, as we've seen. And yes, there's a cost to that. There will be less speech that people would be, fewer opinions that people would be exposed to, that Americans would be exposed to, that they might find of interest, but the risk is really high, and the integrity of our electoral process is so sacred, I would even use that word, as I just did, that it would be worth.
Speaking of, wait, because we have limited time, let's just assume for the moment that we're interested in fake news generally, not just simply from foreign countries, but fake news coming right here in the USA. Yeah, American-made. The best kind of fake news is American-made fake news. The question I guess I'd ask is it a problem? If it's a problem, is there anything that we can do about it consistent with the First Amendment? Assuming that it's born in the USA, fake news.
It is a problem, but it's not a new problem. So we've always had fake news. I worked as a fact checker for fact-checking is really problematic, and we could talk about that. But I worked as a fact-checker for a couple of years before going to graduate school, and I worked at a progressive organization, and I saw the ways in which fake news could propagate through the conservative echo chamber. And I'm sure this happens on the left, I just haven't witnessed it. So you could watch how the idea that Barack Obama isn't an American and he shouldn't be able to be president, the birther smear, you could watch that develop through the right-wing echo chamber. And, you know, so fake news is not a new problem, but the way in which fake news happens today is much more problematic.
Barack Obama was president during the age of the internet. So you're talking about the 1920s.
Well, this was before.
That Warren Harding was actually not born in the United States.
But this was before, I think this was in like 2007. And this is before what we've seen. I think there's been a shift in terms of the scale and scope of what platforms are doing. And what we're seeing happening on Facebook today is very different than what Facebook was in 2006, 2007. And what's different about the way fake news operates today in terms of it being, to your first question about what kind of problem it is and is it a significant problem, people are experiencing fake news today not as something that they see like on Fox or on MSNBC. They're experiencing it in a way that is so targeted and it's scalable, and they're experiencing it on Facebook where they believe that that is their entire reality. And they believe that other people who are on the platform also experience that reality. So it's a sort of metastasized filter bubble where you're not just in your own silo, but you believe that everyone else is experiencing the same silo that you are. And this is a phenomenon that scholars like Zeynep Tufekci and Tarleton Gillespie have documented, and it, I think, speaks to why fake news is a bigger problem today than it was 10 years ago, and why it's a sort of qualitatively different problem.
And your view is, is there anything we can do about it?
So, because it is caused in large part, this shift in the qualitative shift in why fake news is a problem is caused by the business model of a lot of these companies, I think there's a completely non-First Amendment remedy, which has to do with looking at their business model, regulating them in ways that have to do with the way they're structured, the way they monetize data. Like, that might get to your last question around Cambridge Analytica, but I think we could potentially regulate the way that they do their business, and that would change the incentive structure.
Would they not raise a Central Hudson objection to changing the way in which they broker advertising? Or am I missing something?
Potentially, it seems that we could tell them that maybe that would be a problem. In which case, we could move to the fact that they're monopolies, and we could try to break them up. And that would be, I mean, that might be too extreme, but that would be a way to go after the size and power that they have in the market in order to deal with the ways in which they're so effective and so powerful in shaping our experience of what's true and what's false.
But then even if we had 10 smaller Facebooks, couldn't foreign governments just sell ads to every single one of those smaller Facebooks?
Well, here we're assuming domestic. That is to say, forget about
10 local.
Right. What do you think about this?
I mean, I think fake news is a problem. I don't think it's a novel problem like Morgan, but I would go a little bit further back to the 19th century. It seems like in some ways a reversion back to an older period where we had
You know that Abraham Lincoln wasn't even born in Illinois.
Shocking. Was he born in Kenya?
No, but he was born in a state that began with a K.
Oh my God, foreigner. Just like me. So in the 19th century, there's, in some respects, like today, lower barriers to access because you have lots of local newspapers. You have many more federal subsidies of newspaper circulation through the mail. And you have newspapers that don't have the modern professional standards, and so they're just tabloids that have particular partisan slants, and there's tons and tons of fake news. I mean, I think the 19th century media sphere looks a lot closer to the contemporary media sphere than the 1950s. And then you start to get consolidation and centralization of the industry. I think it's in part a response to the taking away of the media, the subsidies, the mail subsidies for the newspapers, which means that a lot fold. Get fewer, bigger players. You get higher barriers to access, so you get fewer players, so you de-democratize or whatever. You increase monopoly control or oligopoly control, but you develop professional standards. And so we can, I mean, I think it's glass half full, glass half empty. The glass half full view is that fake news is a consequence of the decrease of barriers of entry to the media and the democratization of our media sphere. We're in a much richer media sphere than 50 years ago in some ways, but it's much less regulated. And so we need something to take the place of the old professional journalistic standards that used to govern and don't do the job anymore. And that's why I don't think it's impossible to think of things like, and the government can encourage, I don't know if the government should control, but third-party agencies that develop these kinds of disclosure, fact-checking of a certain way, three Pinocchios, two Pinocchios, or ways that consumers of news can use to evaluate the quality and the origins or something of their media. Because the problem with this much richer media environment is you have no idea where it comes from or how much validity it has. But I don't think we need to say, oh yeah, we've got a really rich media sphere, let's make it less rich. Let's cut stuff out. I think there are things one can do.
So Brandeis is right.
Yeah.
Yeah, there you go. Do you agree, Enrique? Brandeis is right?
I have a couple of priors to reveal here to answer this question. I'm not on Facebook. I don't know if that makes me uniquely qualified or uniquely unqualified.
Well, you don't know that you're on Facebook. They do have a dossier on you.
There may be a shadow me. But I've also read a lot of the social science literature about fake news, and I tend to agree with what I think, at least what I've read, the majority of that work that says that political activity on social media is really intended to confirm, and has the effect of confirming rather than persuading.
And you already believed that when you read the
That's right, exactly. I suspect Morgan will say that, don't make too much out of that difference, right? Polarization is a harm, just like persuasion based on false information is a harm. But if you look at it like that, if you think that Facebook is speech and it doesn't actually persuade people, then you have to find another way to get excited about it. And I think you have to look at it as an attempt-based crime, so to speak. You have to say the attempt to use false information to manipulate someone, whether or not it is successful, is a harm that needs a remedy. And once you kind of frame the problem like that, then I start to get really uncomfortable from a First Amendment perspective. I mean, I think then it kind of starts to look a little bit more like U.S. versus Alvarez than a threat to the Republic. And another plug for FESC, Alan Chen has a paper tomorrow morning where he makes an argument that there might be a First Amendment right to receive fake news, because it plays a role in signaling, it plays a role in self-conceptualization. When you hit a like on a story that turns out to be fake, you're saying more about you than you are about anything that's necessarily in that story. So my view is
that people were signaling something when they said, oh yeah, I believe Barack Obama was not born in the United States.
Right.
They were doing something.
Right. Well, whether or not the underlying fact, objective fact, was true or false was, in most of these cases, I think, irrelevant in terms of how people actually use social media. But having said all that, I mean, I do think polarization is a problem. I think the question is whether or not polarization is a problem that the First Amendment permits the government to do anything about.
So that brings me to a slightly different problem, not the problem of fake news, but the problems of harassment, cyberbullying, and revenge porn. These are, what can I say, the paradise of the internet has brought us all these wonderful things. Is there anything that you would recommend that governments could do consistent with the First Amendment to combat online harassment, cyberbullying, and revenge porn? Do you want to start on that one?
Yeah, I think the revenge porn criminal statutes are off to a very difficult start. The First Amendment is winning those battles. You saw this in the recent case that came out of Texas. A revenge porn criminal statute is almost impossible to write in a non-content-based way.
Although I do have to say that the way in which the court read the statute was designed to basically sweep away a lot of difficult problems. Its reading of the statute was quite strained, but it did that essentially because it was convinced the statute was unconstitutional. It just wanted a quick way out.
Right, right. I think that's fair. So, you know, if you're committed to this project of criminalizing revenge porn, and I think we all should be, the challenge is that you have to come up with a way to say that this harm is different than the harms that lots of other laws are pointed at. You know, public disclosure of private facts, intentional infliction of emotional distress, breach of implied promise. That's the challenge, because if other laws go to the same interest, then any revenge porn criminal law is going to have a real problem on least restrictive alternative grounds when it comes up against the First Amendment.
Is it your view that harassment is protected online too? Which is a different question than revenge porn.
So, harassment laws that are not content-based have a much better chance of survival, and that's true. That's true in the online space as well as in the walking down the street space, right?
Right, but this won't be somebody following you around the street. It'll be sending you a series of not necessarily threatening, but messages basically saying terrible things about you, saying terrible things about your family, right?
Yeah.
In other words, threats, clearly. Online threats you can go at, but most harassment is not necessarily threats.
Yeah, well, I think, you know, is cyber stalking any different with respect to its essential elements or with respect to what the government has to prove than stalking in the non-virtual world? I mean, I think that's, I think those cases are fairly easy to bring and win.
Yeah, and I think it only goes to show how constricting current doctrine is, that the court has never been able to explain why harassment laws are constitutional under the First Amendment, right, but has never struck them down. And I think the court assumes that they're fine because they're targeted at a particular individual. They do what it seems they're intended to do, clear harm. They constrict that person's autonomy and their ability to speak. So it doesn't seem to me like exactly this. I agree that the cyberbullying and harassment laws don't seem to me to pose a problem, even if we don't have any Supreme Court case that explains why they don't really pose a problem. It seems, and like
even if courts keep striking, lower courts keep striking down the laws that get passed.
And the easiest way to protect people from revenge porn,
like a mistake.
The easiest way to protect people from revenge porn has been completely foreclosed, which is to just find that it's unprotected speech. I mean, revenge pornography sits very comfortably on all the justifications that the Supreme Court gave for finding child pornography unprotected. But you had this case, United States versus Stevens, where the government actually tried to make that argument with respect to animal cruelty, and Chief Justice Roberts says that's a startling and dangerous proposition. The idea that we balance, you know, harms versus benefits in speech to find speech unprotected. Well, in fact, that's what the court's been doing for decades, even going back to Chaplinsky.
So you would create a new category of unprotected speech called revenge porn, which would be defined as?
The non-consensual posting of intimate material for consumption for people other than for whom it was intended. That shows some kind of you can go as far down the specific definitions of the material that's being shared as you would care to.
I don't know why you need that though. I mean, think about, so in Cohen v. California, right, the Fuck the Draft case, I think Holland writes the opinion and he says you cannot prohibit speech because of its content except, you know, when it's likely to incite violence and sort of an extreme invasion of privacy, something like that. It seems like at the time, seems like an extremely high standard, but I don't see why a revenge porn couldn't be found to satisfy that standard. This seems like if privacy is the rubric we want to use, it seems like a very serious threat to privacy. Right. And so I don't think you need to say it's excluded. You can just say this is the kind of harm that the First Amendment doesn't prevent the government from regulating speech to prevent, because it's a very serious and significant harm. So I think revenge porn is harder because it's directed to the third party. It's not so much about trying to force someone to do something or prevent someone from doing something. It's spreading a message about someone. Typically, we protect people's ability to spread messages, right, particularly messages that have a particular viewpoint, like she's a slut or a hater or something, whatever. Yeah. But it has such serious harm that I feel like this also should not be very difficult. It's a very serious invasion of privacy. We should allow our doctrine to be flexible enough that very serious invasions of privacy you can regulate again.
Especially when it has such slight social value towards the truth, which again is exactly what the court did.
Well, I don't know if I want courts getting into the business of evaluating social value, but that's another conversation.
Yeah, but implicitly there isn't a claim at social value. Right? In other words, because, for example...
What if in that...
Let me give you an example. There's a PP tape. Let's suppose there really is a PP tape.
Okay.
This strikes me as revenge porn. Or you'd say, no, but the social value of the PP tape is great. Therefore, we have to be able to see the PP tape. Mm-hmm. Right? So you'd have to get into the business of saying that this is a matter of purely private concern, mm-hmm, with no public interest behind it, which is heavily embarrassing. Mm-hmm. And which is outrageous. No ordinary person should have to put up with it, right? Whereas if it was a matter of public concern, I'm sorry, you have to put up with it.
Yep.
So you really have to talk about social. Yes, what is your view?
I agree with what you've all said, and I think when it comes to cyberbullying and harassment and trolling as distinct from revenge porn, those sorts of activities are so contrary to the First Amendment value of participating openly in a democratic society. They so effectively silence people, and their purpose is to silence people, to push people out of public spaces of discourse, where I think that must be the kind of harm that the First Amendment should care about and should want to address. So I definitely think we should be addressing those sorts of things.
Actually, it turns out that one of the reasons why we don't protect certain forms of libel is tied to the very point you made. That is that people are concerned that where there's no public figure involved, defamation against a private figure, especially on a matter of purely private concern, will basically prevent them from participating in public discourse. I have time for one more question, then we have to open it up to questions. So I hope we can go through this quickly. It's a really simple question. It's not difficult at all. Given the recent scandals with Facebook and Cambridge Analytica, how, if at all, could the government regulate Facebook consistent with the First Amendment? As you see, this is a very simple question. It's not very difficult at all.
Jack, the answer Jack wants is information fiduciaries.
I wasn't begging for an answer.
But even setting aside his excellent work on that point, in addition to an information fiduciary regime, which I certainly consistent with the First Amendment because Jack developed it.
As I said so, it's consistent with the First Amendment.
I think there's also an opportunity, since the harm that we're really worried about when it comes to Facebook and Cambridge Analytica is about data. And we have an opportunity, I think, here to, in addition to your proposal, to sort of reconceptualize what we think we're talking about when we talk about data. And in the United States, as we all know, data is understood as a work product creation of corporations. Whereas in Europe and other places, data is something that is understood as part of yourself. It's something that's yours, it's something you own, it's your arm, it's like your DNA. And I think there's an opportunity to reconsider how we think about what data is in this country. And yet again, we see the specter of First Amendment opportunism here. I think many people would respond to what I'm saying by arguing that, well, data is speech, and it's the Corporation Speech Act when they've created data about you and then amassed it and then analyzed it in certain ways. And I think of that type of First Amendment argument as an example of First Amendment opportunism that's operating at the margins of the core purpose of why we have First Amendment protection. So I don't think of it as a core normative argument that's tied to why we should care about
the First Amendment is not a serious problem in your view.
No, it should not be.
Okay.
I think people would argue it is, but I think they would be.
Well, you know those people.
I do.
Enrique, what do you think? Are you one of those people?
Well, I mean, what we're really talking about here is surveillance capitalism. And the government is not necessarily your friend. The surveillance state loves surveillance capitalism. There's a book by Morozov called The Net Delusion. When he wrote it, people thought you're a Cassandra, and now people are saying you're a prophet. And he talks about how much work it took the KGB to spy on one person. Like, you had to buy the apartment over his apartment, and then you had to run the wires and tap his phone, and then when the volume wasn't high enough, you had to have fake suits so you could go in and pretend you were fixing the TV. That's not the world we live in anymore. It's the first 6 months of 2017, 32,700 requests to Facebook from the government for data. So resulting in turning over data 85% of the time. So we have to be careful here with respect to our expectations of the government. So, and on the issue of information fiduciaries, Justice Frankfurter said, to say that a man is a fiduciary only begins the analysis. It gives direction into further inquiry, like the scope of the duty, which Jack, when he writes about this, he says, well, that's the real question, the scope of the duty. So when I was thinking about the scope of the duty, it caused me to do something that I may not have even done since law school. I got out my Cox and Hazen corporations, and I started reading about fiduciary duties. And one thing I thought was interesting and potentially relevant, and that's the no profit rule. So a fiduciary can't profit from the relationship with the beneficiary, an opportunity created with that relationship without giving the beneficiary full and informed consent. So what if Facebook had to tell you exactly how much money it made off of you, and then offered, said, you can give us that money, and we won't do, and we'll be more careful with your data. We won't give it to access to it, to our advertisers, to your data, if you basically let us recoup the cost that we would otherwise use if you were using the service for free. And if there's no amount of money that Facebook would take to do that, then we got to start thinking about another Facebook. Because if there's so much value in what we give it, that we wouldn't be able to replace that with our own money, I think that is a function of as Morgan said, the business model rather than the relationship.
Genevieve, what do you think? And first of all, how much do you think your Facebook profile is worth?
$22.76.
All right, very good.
I would actually,
That's a good guess.
Average revenue, $12 per person.
oh,
Well, you're a valuable person.
there you go.
Much more than 12.
I don't understand why this is a difficult question. We regulate the disclosure of data all the time in all kinds of ways. And in fact, to Enrique's point about we worry about the government, well, that's why we regulate the way in which government uses that data. There are strict rules regulating when governments can transmit personalized data, medical data, other kinds of data that the government gathers between one department and another, precisely because of the risk of abuse. Now, of course, it's not perfect. But that seems to me only to call out for more data regulation, not to be worried about.
So just to make it a little bit clearer why people would be worried about it.
Yeah.
I guess the first thing would be that the government, of course, doesn't have First Amendment rights in the same way that private companies do. And secondly, it's clear that restrictions on use of data are generally don't pose First Amendment problems. So restrictions on use are usually consistent with the First Amendment. It's usually the restrictions on an analysis or the creation of new data or on the distribution of the data. So in Facebook's case, Facebook doesn't sell its data to other people, but what Facebook does is it creates a lot of metadata, which is not just simply information about you, but information about lots of people, which it combines with information about you, that's creating a new product. There's a new form of data, which it then uses for many different purposes. And then what it does is, this is tied to your previous discussion, it hooks an advertiser up, or potential advertiser up, with its analysis in order to sell advertisements. So this would, I can think of several places in this story where Facebook would make a First Amendment claim. It might make a claim based on commercial speech, but it also might make a claim just based on regular free speech, the right to analyze and collate data. So I think it's not about, I think I agree with you that restrictions on use, not a problem under the First Amendment. I think it's the other problems.
But I think we address those problems if we change the way we think about data and who owns it and who, if it's the company's property and they've created something new, then they have a much more credible First Amendment claim that, oh, well, we've created this new thing and we're analyzing it and we're linking it up with advertisers and that's our property and that's how we make money and you know that's our original speech. But if the data is in the first instance mine, then it's I think that starts to break the nexus that the company has to claim that they're creating something new out of something that's mine.
Well, I guess I think in analogies, so forgive me for all the analogies, but it's useful for me to think through the medical data, medical information, because this is also information that people really care about, information that has tremendous value, commodity value, and information that is heavily regulated. So with medical data, there's two different types. There's individualizable or individualized and non-individualized, and most of the regulations that restrict dissemination are about individualized. The government doesn't worry that much about non-individualized, and then there's fights about which bucket you fall in, but there's the two buckets. So Jack, to your point, to the extent that we're not talking about individualized use of data, I guess I'm not that worried about it. It is Facebook's user model. It does allow advertising. We may have other concerns, but that doesn't seem like that's the Cambridge Analytica problem. The Cambridge Analytica problem was that this data was being used to target individual
Well, I just want to say that from data profiles that were available from Cambridge Analytica, one could predict Enrique's behavior. That is, even though he's not on Facebook. The great thing about the surveillance capitalism and our algorithmic society is it is no longer necessary to actually collect data from subjects in order to be able to make plausible inferences about their behavior and thus to manipulate them.
And these are including people who didn't even choose or agree to take the little quiz that Cambridge Analytica provided. So people who didn't have any sort of notice about whether or not their information would be collected for these sorts of purposes, which seems very problematic in terms of consent.
To the extent that they're being personally targeted, this is just about making rough predictions about demography.